proceed from where I left off. Mr. Nambal testified that the amount received between July 2022 and November 2022 were 960,000, 500,000, 550,000, 250,000, and 50,000 from policy supply and into the applicant's personal bank account. The applicant testified, Mr. Nambal testified that he came across the approved budget of Windhoek for the year 2022 and 2023 in the amount of 25 million, and board approval would have to be sought for the movement of funds. He testified that the board only became aware of the acquisition in April 2023 after it had received an anonymous report in April 2023. Mr. Nambal testified that the NAMCO's consolidated APEX budget, what is marked as the F2, provided an approved budget or budget approval of 25 million. Anything above that would require board's approval. Mr. Nambal testified that they arrested the applicant first from all the other persons, as he was a frequent traveler and feared that he would not return or would flee to South Africa. He testified that the arrest was a joint effort between the ACC and NAMCO, and the applicant was apprehended at his house in Windhoek. Mr. Nambal testified that the arrest was made by the Windhoek police, who had the authority to execute the search warrant. He testified that Commissioner Becker executed the search warrant and accused him of a copy of the search warrant and informed the accused of his legal and constitutional rights in his presence. Mr. Nambal testified that in order for that, for them to get into the property of the applicant, someone had to jump over the gate. The gate was eventually opened from the inside and they were able to walk in. He testified that the applicant had locked himself in the room for 1 or 2 hours and he had been in the bathroom, after which they threatened to break down the door and the applicant opened the door. He testified that they entered the room and the applicant's cell phone was ringing, with calls coming from Mr. Simanika as well as from Mr. Muharukua. He testified that the applicant was calling his fellow accomplices, as he put it, and although he did not look or search for call records at the time of the arrest, he stated that not an hour passed before Mr. Malima had crossed to the border of Chicago. Mr. Nambal testified that on that particular date, they seized applicant's cell phone, laptop documents, including the vehicle registration documents and farm documents. He further testified that the applicant was asked about any chronic medication and illnesses, and the applicant informed the Baker that he was diabetic. He was requested to carry his medication with him to the police station, which he elected not to do. Mr. Nambal testified that the day the applicant was admitted to the CMS hospital, he received a call that the applicant was being exported to hospital by a certain Mercedes-Benz GLC63 white SUV. He testified that there were 2 other law enforcement colleagues and he found the applicant in a single police van, and the applicant was at the back of the van and the police reservist was behind the police in the GLC. He informed court that the senior police officer in the car had narrated that they did not have had adequate transport, and as a result had requested for the reservist to assist with transport, and the police van they had used was borrowed from the Klein Windhoek police station. Mr. Nambal stated that the senior officer is a reservist in the reservist vehicle, was cautioned, and a misunderstanding was cleared, and the officer was excused, and Mr. Nambal proceeded to escort the applicant Mercedes vehicle was released at the Correctional Services Facility. Mr. Inambao testified that the biggest fear they have is the suspect fleeing, especially a foreigner or someone with dual citizenship, especially that they had just returned a debit card of the applicant and a vehicle to the applicant's sister. Mr. Inambao, in response to the state prosecutor questioning why such a hospital incident was not put to the accused or Mr. Muharukua, Mr. Inambao testified that the police reservist had a relation to one of the accused in the matter, but would not disclose which accused, and further refuted that the hospital incident had any connection to Mr. Muharukua, that no evidence showed Mr. Muharukua's involvement. Mr. Inambao testified that no bail conditions can be proffered and objections to bail remains. He further testified that they feared applicants' dual citizenship or nationality as a result. They feared the abscondment, that it was very high. He further testified that the accused had been sending money to South Africa, to bank accounts in South Africa. He further testified that there is indication that the accused had sold property in South Africa, and that there's indication that such monies is still believed to be in South Africa. He testified that the applicant is facing serious charges and the risk of evading is high. Mr. Inambao testified that the two passports are in the possession of the ACC, which were seized on the date of arrest. They testified that the European ID and the South African ID is in possession of the applicant's lawyer, Mr. Isas. Mr. Inambao testified that interference into investigations by the applicants is high as part of the money of the applicant remains in South Africa. He further testified that the transactions are complex, involving money laundering, multiple persons, and multiple transactions of money. Mr. Inambao testified that NAMPO is a public enterprise, and NAMPO Trading and Distribution is registered as a private company, and its primary duty is to carry out the parent company, which is NAMPO Holdings. And NAMPO Holdings receives government levies, which benefit NAMPO Trading. He further testified that NAMPO receives bailouts from government, and the case revealed that there are activities relating to money laundering, which have been covered by the media. From the evidence presented to court, Inokon was about a payment of 15.5 million, and further he testified that it resulted in about 65 million, and the debt recovered was issued by NAMPO in 2023. Mr. Inambao informed court that close to 400 million was lost, and they have demonstrated a strong case and conspiracy dating back as far as 2021 involving NAMPO's property. He declared that it would be in the interest, in the public interest, and the administration of justice that accused be remanded in custody and denied bail. He further testified that the suspects are still to be arrested. There are suspects still to be arrested, and bail proceedings have slowed the investigators in terms of investigations. He further testified that with adequate staff, it may take about 4 to 5 months to finalize investigations. That is in terms of the local investigators. He indicated that we cannot say how the other parties outside the country would have to assist the local investigators, how investigations will transpire in terms of the investigations outside the country. Mr. Inambao further testified that the invoice of property to Eco Trading made on July 2022 of 1,040,000 presented to him by is a fabrication as the transactions into his personal account only started after the practice as a case agreement. I now move to the law. The onus is on the accused to satisfy the court on the preponderance of probability that he is a suitable candidate to be released on bail. In S. specifically C's 1992 letter, at the time Judge Pauline stated that the liberty of a subject, fair trial, and the principle of an accused person is regarded as innocent until proven guilty. And stated that these very important fundamentals, rights, are however not absolute but circumscribed and subject to exceptions. Further, Section 61 of the Criminal Procedure Act states that if an accused who is in custody in respect of any offense referred to in Part 4 of Schedule 2 applies under Section 60 to be released on bail in respect of such offense, court may, notwithstanding that it is satisfied that it is likely that the accused, if released on bail, will abscond or interfere with any witnesses for the prosecution or with the police, refuse the application for bail. If, in the opinion of the court, such inquiry, as it deems fit, is it deems necessary, it is in the interest of the public or the administration of justice that the accused be retained in custody pending his trial. In S. Atchison, 1991, Judge Mohammed, as he was known then, emphasized that an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. In Charlotte Water v. State, Judge Pauline stated that a judicial officer will therefore obviously have to make a valid judgment of what are legal convictions of society and what is the impact of such convictions on a particular case where court must adjudicate on a bail application. In Bronco v. State v. Bronco, 2002, Acting Judge Shakalia stated that the fundamental objective of bail in a democratic society is to maximize personal liberty. The proper approach to a decision in a bail application is that the court will always grant bail when possible and lean in favor of and not against a subject, provided that it is clear that the interest of justice will not be prejudiced thereby. In Cunha v. State, a full judgment was delivered on the 14th of October 2022. It was stated by the three judges or the full bench, the net is cast wide. To the extent that the court has the discretion to refuse bail in public interest or the administration of justice, even if it is satisfied that on a balance of probability, it is unlikely that the accused will respond or interfere with witnesses or investigations of the case. Bail can accordingly be refused if the presiding officer, after consideration of all facts placed before the court, is satisfied that there remains a reasonable possibility that the accused will abscond or will interfere with state witnesses or will interfere in the investigation. This would play a vital role where it has been established that a strong prima facie case against the accused or where the accused elects to the evidence and admit guilt. To this extent, this would count against the accused for release on bail because of the public interest or the administration of justice. Further, in that same case, it was stated that other factors considered in the Section 61 inquiry include whether there is a strong prima facie case that the accused is guilty for one or more serious offences, the likelihood to commit offences, the probable further sentence as incentive to abscond, the nature and gravity of the manner in which the offences are alleged to be committed, the state of police investigations, previous convictions, the circumstances under which the crime is committed, and whether the public must be protected against a dangerous offender, the propensity to commit further offences, whether there has been history of committing suicide, medical condition of the accused, multiple serious crimes, serious escalation of crime, and the escalation of accused persons evading the course of justice by absconding. In my analysis of the evidence, there are facts that are common in terms of the evidence, and as provided in the bundle of unopposed documentary evidence handed out, the court is grateful to the parties specifically for the documentary evidence, for it sets common matters in perspective. It is common cause that the applicant entered into a year-long consultancy with NAMPO to provide consultancy services to NAMPO commencing the 1st of June 2020, which agreement was subsequently extended and lasted until the 1st of June 2022. Per the unopposed oral evidence, on the 9th of May 2022, applicant was offered permanent employment as a supply and distribution manager, downstream and supply and logistics department of NAMPO. The applicant held this position until the 15th of November 2023. 1 month after assuming the position, he also acted as the sole executive for supply and logistics. The job description, which indicated a supply and distribution manager, entailed the development, refining, managing the operational capacity of downstream logistics department, ensuring effective supply of oil, petroleum products as per market, customer needs. It is also charged with the commercial and marketing function, the optimal storage and distribution of these products in order to ensure availability of NAMPO's products in target markets, and the positioning at the customer's premises to optimize sales of this product at all times. The bundle of documentary evidence handed out to court also contained the schedule of authority for NAMPO signed by the chairperson of NAMPO, Board of Directors, and in terms of the schedule, it stated that this policy is implemented to ensure that the management has appropriate legal authority to exercise powers and to carry out certain actions for which they are individually and personally accountable. It also sets out the procurement approval levels for each policy and reporting breaches. Further, NAMPO financial policies and procedures dated 2007 sets out procedures regards acquisition of fixed assets for acquisition of items not budgeted for. Accordingly, the MD is the approving authority, subject to the approval of the board. The credit policy of NAMPO, which is also provided in the bundle, sets the guidelines for the consideration of extended credit terms to NAMPO's customers for the purchase of fuel, jet fuel, and maintenance. The object of the policy was to ensure that all monies that are due in payroll are collected within the terms set out by the conditions of credit. The policy aims to reduce bad debt and to manage the risk associated with granting products on credit. As per the credit policy, the credit applications up to 500,000 are reviewed by the credit committee and reported for approval. It is worth noting at this stage that it is common cause that the applicant was acting executive for downstream supply logistics from July 2022. As per the internal memo dated July 2022, the credit policy states the rules and all credit applications above 500,000 should be reviewed by the credit committee and recommended for approval by the managing director. The policy for this stipulates that NAMPO Executive Finance, Executive Downstream Supply, and the managing director will take all credit decisions relating to customers, including credit limit determinations and all allocation to individuals operating units as recommended by the committee. The NAMPO customers will also map out into categories. The risk categories will be influenced by the customer's creditworthiness from low risk, categorized as A, medium risk B, high risk C, and low secure credit D. The fuel supply agreement between NAMPO and the petroleum between NAMCO and Enercon came into force on the 15th of July 2022, and this time the applicant was a permanent employee of NAMCO as a manager of supply and distribution and sole acting executive in logistics. The applicant presented evidence explaining personal circumstances summarized above. He denied any criminal activity and that the general increase of credit limits in NAMCO presented an anomaly and business decisions were made for NAMCO's increased credibility. He contends that his involvement in the transactions was merely an advisory capacity at the instance of the managing director. Further, that he possessed no power or authority to make the decisions. The applicant states that the business dealings with Mr. Malema policy and supply were clearly far business relations or conflict with NAMCO, and at the time he was involved with Mr. Malema, Eco Fuel had already ceded debts to NAMCO without his involvement or engagement. The applicant denied any corruption, fraud, theft by false pretense, money laundering, and any conspiracy with NAMCO staff and Enercon. He further informed court that he would plead not guilty to all charges and would afford bail of a maximum of 20,000 if any conditions were placed. He would comply. He denied having any plan to abscond and that his business and family were rooted in Namibia regardless of his dual citizenship. He invested in a farm which he intends to create a game lodge into a game lodge and has no intention to move to South Africa, clear his name and restore his finances. The state alleged evidence of the transactions that were made into the applicant's personal bank account, that such money was transferred from Enercon, Eco Trading, and the beneficial being Mrs. Manika Victor Malema, and an amount of 3,010,000 was paid, and these transactions occurred between July and December 2022, when the asset was purchased in force. It is the state's contention that the 3,010,000 paid into the applicant's standard bank account is as a result of bribery money for the asset purchase agreement that had been signed between Enercon and NAMCO. The evidence presented before court is that no transactions of similar nature had taken place before the conclusion of the asset purchase agreement. It further appears to be the state's case that the flow of money between NAMCO, Enercon, Eco Trading, Quality and Supply CC, and the applicant coincides with the asset purchase agreement. Thus to say that the state seeks court to conclude that the money that ended up with the applicant was for nothing else but bribes and proof of corruption on the applicant's part. The state would have court believe that the applicant was a conspirator with other executive members at NAMCO still accused in the matter. The applicant's defense is that he was an employee of NAMCO, tasked with the duties of being a member of the credit committee, applying the credit policy with a holistic approach in the furtherance of the business affairs of NAMCO after July 2022. It is further his defense that he was in no capacity to take a decision for the conclusion of any of the agreements in question, and that his involvement before July 2022 was confined to supporting role within the limitations of his position held at relevant times. And I pause here to revert to the state's specific grounds of objection, which is the risk of interfering, the risk of abscondment, the seriousness of the charge and extent of the state's case, outstanding and suspects and investigations, public interest, and the administration of justice. For the purposes of this ruling, the two grounds of objection, which are the risk of interference and outstanding suspects and investigations, will be discussed at length. The state has informed court that investigations are pending that require an additional 4 to 5 months if they are adequately staffed and that there are outstanding suspects to be arrested. The fact that investigations and outstanding suspects are pending should not in isolation be a reason to refuse bail to the applicant. One of the factors that the court must consider to determine whether the applicant is likely to interfere or tamper with evidence particular witness or investigation that he could interfere with, since documentary evidence was already with the ACC officials. Indeed, the accused bears the promise that he will not interfere with investigations, and the state cannot raise objections and sit back without bringing credible evidence before court to support this objection. In the hope that the accused will not escape the evidence, the objections of the state must be serious, for incarceration encroaches on a constitutional right to liberty and should be done so within the constitutional limits. In this instance, there is no evidence before court to suggest that indeed there is a serious risk of interference with investigations or with witnesses, or that the accused will in any way impede the arrest of any other potential accused person. Further, the court is of opinion that there is no sufficient evidence before this court that bail conditions cannot address that fear of interference. It is for this reason that the court will not delve any further with regard to those specific grounds of objection. This leaves the court to consider the risk of abscondment, the seriousness of the charges, and the strength of the state's case, public interest as well as the administration of justice. It is tried, and it is settled in our law, that in essence the question of the administration of justice and the public interest in bail applications entails the consideration of all other grounds of objection to judicial practice of the court, such as the abscondment, for which the seriousness and the strength of the state's case are amongst the factors to be considered. For if the label of the state's case is so serious that evidence against the accused is so strong that there is a likelihood of conviction at trial as to induce the accused person to skip bail because he fears the lengthy incarceration. I now turn to the personal circumstances of the accused person before court in relation to the applicant. Indeed, the applicant is connected to both South Africa and Namibia. He holds dual citizenship of both countries. He has families in both countries. He has been a frequent traveler between the two countries. He contends that he is rooted in Namibia, established himself in Namibia, and has chosen Namibia as his primary home between the two countries. He has a farm to the value of 9 million. He lives in Namibia. The two of his children reside in Namibia with their mother, where they are now schooling. His siblings live in Namibia, and his mother resides in Namibia. The defense argued that the state is solely relying on his wealth, but he argues that it has been a way, that he has been a way of investigation since 2023 and has not pervaded or left the country. This court is of the opinion that, as was discussed, an extradition treaty between Namibia and South Africa is a factor that increases the possibility of the state being able to bring the accused person to court should he respond. The further question remains, however, whether or not the charges and the state's case could be a catalyst for the accused person to abscond. Indeed, it is common cause that corruption is unacceptable in Namibia. Taking into account all policy pronouncements by government, followed by the enactment of the Anti-Corruption Act, various other related legislation, the approach of superior courts in sentencing, and bail in corruption cases. These have been a response to a public outcry and an abhorrence with which the Namibian society views corruption. There is therefore no question that the labels of the charges against the accused person applicant are serious and carry a substantial sentence if convicted at trial. I refer to the case of S. Windhoek. And I'll just read the first paragraph in the judgment. Judge Windhoek stated that it must be remembered that traditional grounds relevant during the bail inquiry include the seriousness of the offense, treat the state's case, whether the accused will stand trial, whether the accused will interview with witnesses, and whether the accused is likely to commit similar offenses if released on bail. And these traditional grounds culminated often question whether the interest and the prejudice would be prejudiced if the accused is gone to bail. The court reiterates, however, that the label of the charges alone is not sufficient to sustain the objection of the state on any charge, regardless of how serious the charges are and the sentences may carry. The court must therefore take into account the strength of the evidence against the applicant. The state contended that the applicant received 3 million in gratification from ENACON and between 2018 and 2023. The applicant corruptly received gratification and increased credit limits of ENACON beyond authorized limits to NAMCO's actual loss of 30 million, over 30 million, and corruptly facilitated the acquisition of assets above 33 million in favor of ENACON, and that he falsely represented to NAMCO that as a supply logistics manager, he had authority to authorize his supply above the credit limit. The applicant denies all the charges as per the annexures, and under cross-examination, the applicant contended that he does not deal with customers. The only time he does is when they review credit limits or they will deliver fuel through his team. The nature of these types of commercial crimes is that the actus reus would not be obvious. One would expect that the offender would conceal their corrupt reasons using what appears to be legitimate business. Court is therefore specifically of the opinion that an explanation to these transactions by the applicant has to, on a balance of probability, hold water. To demonstrate that on a balance of probability, he has a plausible defense and is unlikely to be convicted at trial. In a bail application, the purpose of so demonstrating is to emphasize to court that regardless of the charges that he faces, he has no incentive to respond, and on a balance of probability, likely to stand trial. It is not in dispute that the allowable credit limit of ENACON was 15.5 million, which rose to 55 million. The applicant disputes that it was part of the credit quality, and that the ENACON debt had risen. He was a member only from the 1st of June 2022 when he became an acting executive. The applicant does not deny that customers went beyond their credit limit. In cross-examination, he admitted that they do not just block accounts because of the relationship. There are various factors and considerations, and one such was that ENACON was applying the Namibian Defence Force, and discretion was taken when needed. But it was not just black and white when it came to commercial agreements and contracts. In essence, the applicant denies any criminality in exceeding credit limits, but rather it was an ordinary commercial transaction in the ordinary course of carrying out NAMCO's business activities. The issue of the credit limit and policy system has been described by the applicant as an anomaly, but the credit policy is not cast in stone. But nothing was done because business could not stand still. The anomaly was not fixed, and the provision of credit continued. It is also not disputed that this particular transaction is not the only transaction where NAMCO had granted credits to the client beyond the allowable credit limit. Court must take to this end that there is no evidence before